writing. And a contract should at least list the basic information, so the date of the beginning of employment, when you actually started, the probation period, we'll explain later on, basically this is a trial period, and the basic rate of pay, whether you're going to get paid €6, €7 per hour, the overtime rates, the normal hours of work, whether you're going to be working 40 hours, 45, this has to be listed. The periodicity of wages, it varies. Some are paid every week, some are paid once a month, some every 4 weeks, so it should also be listed. In case of a definite contract, which we'll also explain later on, the length of such contract, whether it is for 1 year, for 2 years, or up to 4 years, the paid vacation and any other vacation leave that you as an employee is entitled to, any fines which the employer can impose on you. We will also explain later, without the necessary approval from our department, the employer cannot deduct wages from your salaries. So the only thing that is acceptable for deductions are tax and national insurance, of course. The contract must also list the designation, so your role, what is the role that you will be fulfilling, the notice periods, that if you decide to leave the employment or if the employer terminates you, the period that you have to respect and notify each other, as well as whether there is any collective agreement within the company. So a collective agreement is basically an agreement between a trade union and the employer, and which normally gives rise to better conditions than the minimum ones stipulated by law. So if there is the case and there is an actual collective agreement within the company, it has to be also listed in the contract. Basically on our website you can also find templates of our contract, so you can compare whether the contracts provided by the employer is according to law. And what we did was that we provided templates from different sectors, because each sectors we will be seeing later on, the conditions vary. So you can compare the contract with the one that you have.
So, as my colleague has explained just now, contracts are very important when it comes to employment, and there can be two different types of contract. You can be either engaged on a definite basis or either on an indefinite basis. And these are very two distinctions which need to be said during the beginning of the employment. So when it comes to definite contracts, this would be for a fixed period, so it would have an expiry date. It usually is for example, a year or 2 years, and every year it would be renewed. When it's expired, it's renewed again, or however the parties decide. And it's important to note that, for instance, if an employee's fixed-term contract expires and is retained in employment, so the same employee stays in the same employment, they will be considered to be under an indefinite contract if the employer does not issue a new contract of service within 12 days. Something else to consider is if a fixed-term contract is terminated without justified reason. So what happens then if the contract is for 1 year and it's justified before, it's terminated before, sorry. So after the expiry of the probation period, the party who breaches the contract, so whoever ends the employment, is liable to pay the party a sum equal to half the full wages that would have accrued had the contract of employment remained in force. Now, and when it comes to indefinite contracts, they would not have an expiry date and they would just be for an indefinite period. However, it is important to note that we also have 0-hour contracts. These 0-hour contracts do not specify the number of hours which the employee is required to work per week. It's basically up to the employer and the obviously exigencies of the work. However, these contracts are mostly used in sectors where the workload fluctuates between sectors such as tourism, English language schools, and entertainment. However, it is important to note that these 0-hour contracts are no longer permissible with the new legislation, and they are only applicable under 2 circumstances. So if the employee is a full-time student, they would be able to be engaged with a 0-hour contract, or if the nature of the activity of the work requires the availability of replacement workers on short notice. This only applies as long as the employee has a full-time employment elsewhere. So this is very important. And with this legal notice, employers must now include in the employee's employment contract the number of guaranteed paid hours and obviously how much they would be getting. every single employee who would be engaged on an indefinite basis would be entitled to work a notice period in case there is a termination from both parties, and every single employment basically it would have different lengths, the notice period. So if you, for example, work up to 6 months, you would have 1 week of notice period. If you work up to 2 years, you would have 2 weeks. It depends on how long you've been working at the same place. Now, what happens if one does not work the notice period? We have different scenarios and we will explain. So if an employee is not given the chance to work their notice by the employer would be obliged to pay the employee a sum equal to the full wages that would be payable in respect of the unexpired period of notice. This happens when the employee is terminated on grounds of redundancy. Another scenario we have is if an employee gives notice, so this is the other way around, and the employee fails to work their notice period. The employee would then be liable to pay their employer a sum equal to half the wages that would be payable if the employee had worked the notice period. And if an employee gives notice and their employer does not allow them to work until the end of such notice, the employer would be obliged to pay the employee a sum of the equal wages again. Any employment can be terminated without notice or obligation to compensate for notice when the length of service is not longer than 1 month or when there is a good and such sufficient reason. So if an employee is terminated on disciplinary grounds, notice period does not apply, for example.
So upon termination, every employee must be paid everything according to law. So the employee has to be paid the proportionate wages until the date of termination. Overtime, so if you worked overtime for example, the 3 weeks before until the termination, whatever the period, you have to get paid for the overtime. Any remaining vacation leave, so if you did not manage to utilize all your vacation leave balance by the termination date, the employer has to pay you for that balance, and also the statutory bonuses and weekly allowances that are basically paid every 3 months. So something that is very important is that if you feel as an employee that your work was unjustly terminated by the employer, you can lodge a case with the industrial tribunal. So you cannot come to us as a department, we would not be able to assist you because it is something separate. You have to get your own lawyer and file a case with the industrial tribunal within 4 months from the date of termination. So if you exceed those 4 months, unfortunately, you would not be able to lodge the complaint with the industrial tribunal. So before I mentioned probation period, and just to give you a brief explanation, a probation period in Malta cannot be longer than 6 months. In the case of a fixed definite contract, for example, of 1 year, it has to be proportionate. So if you have a contract of 1 year, the probation period is of 3 months. The duration of a fixed term contract by law cannot be shorter than 6 months unless there is a justified reason. So the employer must notify you with the justified reasons why the contract is shorter than 6 months. There is another thing about probation, so if you hold a position within technical, executive, administrative or managerial and you have at least double the minimum wage, your probation can be that of 12 months. Normally it is 6 months if you have such high positions, 12 months, and if you have a definite contract, it will be proportionate. Another thing that we as a department get asked frequent questions about is the trial or the training. So trial and trainings are not defined by our law, which is Chapter 452, the Employment and Industrial Relations Act. However, any hours worked or the employer obliges you to work as training, they have to be paid. We do encounter situations where employers argue that training is not paid, however, this is not the case. For us, training is normal working hours, so you must get paid. Even you must get paid for any entitlements such as pro rata vacation leave, pro rata bonuses, and also if in your sector there is a specific rate that applies, for example, on Sunday, and you are still within the training, you must still get paid the extra rate for Sunday, as well as public holidays. Another thing is that if the employer obliges you to attend for training, any courses, whether in Malta or abroad, it is the employer's responsibility to pay for the training. So you cannot be asked to pay anything for training. Something that is also important and it is your right to get is a payslip. So with every wage, you must get a payslip. And the payslip should include as much information as possible. In fact, there is a specific law about it. And it must include the name, so your name and the designation, the role that you are working in, the name and address of the employer or of the company, the pay period for which the payslip covers. So if you are going to get paid from the 1st until the 31st of March, it has to be specifically listed. Any overtime worked during that period, the basic wage and the amount of hours worked. So if you worked 100 hours, it must list 100. If you worked 173.23, it has to be listed. Any vacation leave used during that period has to be also listed. The sick leave, whether it was applicable. Any hours worked on Sundays and overtime and public holidays. And also the statutory bonuses and weekly allowances, those of every 3 months, if they are applicable during that period. Payslip must also mention any allowances or commissions, although as a department we cannot claim them because they are outside of our remit. If you are entitled for it by the collective agreement or based on the contract, you must get paid and listed on the payslip. Any deductions from wages, including tax and NI, they have to be listed, the amounts. And also the vacation leave balance. So the payslip bylaw has to list the amount of vacation leave that you used and also the remaining balance that you have. For you to know, also on our website there is a template of the payslip, so you can again, like the contract, compare whether your payslip is in line with law. A basic entitlement for you as employees is the sick leave. Every employee is entitled to sick leave, however the amount varies, and also when it will be applicable, because in certain sectors it starts after 6 months, in others it starts from the very first day. For an employee to get paid for sick leave, you must provide, and it is very important, provide a medical certificate to the employer. In the absence of such a medical certificate, the employer has the right not to pay you, because your absence, of course, was unjustified. Another thing that you are entitled to is vacation leave. So every employee in Malta is entitled to vacation leave, even if you work on a part-time basis. And for this year, those working 40 hours have 224 hours of vacation leave. For you to avail of vacation leave, of course, you have to get the approval of the employer, so you cannot just simply not report for work. Make sure to get the approval of the employer. And an employee who has not been employed in employment for a whole year, so you don't start from the 1st of January until the end of the year, you will not have the 2 to 4 hours. Of course, you will get the pro rata adjustment. Even if you work less than 40 hours, you will get the pro rata based on the hours that you work. And the bonuses that are previously mentioned, those of every 3 months, we have the one of March, which accumulates from the 1st of October of the previous year until the 31st of March. And then we have equivalent the one of September, which starts from the 1st of April until the end of September. And the amounts for these are 121.16. The ones of June and December are 13510. So the one of June starts from the 1st of January until the end of June, and the one of December from the 1st of July until the end of December. Again, if you work less than 40 hours, your amount will be adjusted pro rata. And if, for example, the one of June, you haven't started from January, but you started in March, you will get the pro rata from March until June.
Now we'll be moving on to wage regulation order. So what would WROs in short mean? So basically, these are different legislations that would regulate different sectors. So for example, if I work at a restaurant, I would fall under one sector. If I work as a construction worker, I would fall under a different sector. It is important to note and identify your own WRO. Now, in Malta we have 32 different WROs that cover different sectors, and these would regulate the section accordingly. They would have different entitlements, different hours, overtime rates, applicable Sunday rates. It depends on the sector. And the way to identify under which WRO the company would fall under is to identify what the main activity of the company is. So what does the company do? And that's the way you would identify a WRO. Now, it is important to note, as I said, that these WROs would have different entitlements that would fall under. For example, if I am a cleaner working at a hotel, but I also work at a private cleaning company, we would have different entitlements, therefore different WROs. That is an important distinction. For example, if a waiter working in a restaurant which is situated in a hotel, they do not get double on a Sunday. However, if it is a restaurant outside the hotel, they would get double on a Sunday. These are the different entitlements that I am talking about. For example, even when it comes to construction, for example, the sick leave, paid sick leave would be entitled after 1 year. And different WROs would have different minimum wages. For example, if we're talking about the national minimum, it would be 554. We are talking about construction, it would be 566, and so on. The different WROs would have different minimum wage. And these would be also accessible from our website, so you can check. Another concept that is important when it comes to working is equal pay. So what is equal pay? Equal pay refers to the employees who fall under the same class of employment and they are entitled to the same rate of remuneration. So if I am, again, a cleaner and there is another cleaner working with me, we should be getting the same entitlements and therefore the same rate per hour. This is an important concept. Not every company respects it. However, we are trying to enforce it more. We also have maternity leave, which is also another entitlement. We have 18 weeks in total, 14 weeks paid by the employer. The remaining 4 would be paid by Social Security, and they are to be availed as follows. So the first 4 weeks are to be availed before the expected date of confinement. We understand that this can be unpredictable, however, it is the way that the law is applied. The following 6 weeks are compulsory after the date of confinement, and the remaining balance of entitlement is up to the employee, so she would decide when to take them. It is important to note that a pregnant employee shall be entitled to time off without loss of pay or any other benefit in order to attend antenatal examinations if such examinations are during the working hours. So, if an employer decides to dismiss a pregnant employee during the probation period, the employer must give the reason or reasons for the employee's dismissal in writing at the time of dismissal to justify that the dismissal is unrelated to the employee's pregnant condition. If the probation period has not been exhausted, so it has not been passed, and the employee starts her maternity leave, the probation period is automatically suspended, so it stops for the time and then continues after the employee returns back to work. And during the first 12 months from the birth of the child, an employee cannot be obliged to work overtime. And when required, special maternity leave applies. And now my colleague will be talking about work-life balance.
So a concept that was introduced in 2022 is the work-life balance law, which basically gave some extra leave. The first one is paternity leave, and in Malta it consists of 10 working days, which are to be taken immediately after the birth or the adoption of a child. And it is the right to paternity leave shall not be subject to a period of work qualification or to a length of service. So even if you've just started your employment, you are still entitled to the paternity leave. And the right to paternity leave shall be granted also irrespective of the worker's marital or family status. The work-life balance also covers the carer's leave, so in Malta it is 5 working days per year, however they are unpaid. And the carer's leave, as an employee, you are entitled for it if someone in your household and has, for example, an illness or requires care or support, you are entitled to such leave. However, the employer has the right to ask for proof, of course, always to prevent abuse. Another thing is the urgent family leave. So since the beginning of this month, it has increased. In fact, now it is 32 hours. So the first 16 hours are taken from your vacation leave and the other 16 hours from your sick leave. And this basically applies when something emergency came up in the morning and you cannot report for work. Again, the employer can request proof to make sure that you are not abusing the system. The most important thing is parental leave. So every parent has a right to parental leave in Malta on the grounds of birth, child fostering or adoption. And basically this is for a period of 4 months until the child has attained the age of 8 years. However, in Malta the parental leave is paid for 2 months and it is not at your actual contractual rate. So even if you have, for example, €7 per hour, you will not get paid at this rate for parental leave, but but at the rate of sickness that is stipulated by the law of the Social Security. Every worker in Malta is entitled to the parental leave per child and irrespective whether you work full-time or part-time. However, to avail of such leave, you have to be in employment on a continuous basis for 12 months. So before having attained 12 months in employment, you cannot benefit from the paid parental leave. And to apply for parental leave from the employer, you must give him at least in writing 2 weeks of notice. So you cannot just simply initiate your parental leave. Of course, the employer has to have the 2 weeks of notice. Now, if you haven't utilized all your parental leave and you are going to terminate your employment, you still have the right to carry on the leave, the balance that you have, to the next employer. In fact, you as an employee can ask the employer to give you in writing, we call it a written statement, with the balance that you have. So you can show to the next employer that you still have a balance of paid parental leave. Paid parental leave in Malta is in established periods of at least 2 weeks. So you take parental leave for periods of 2 weeks. However, if you agree for a shorter or longer period, at least, and has to be agreed between both parties, if you manage to get that agreement, you can of course proceed. With regards to payment, it is paid in a staggered approach. In fact, until the child attains 4 years of age, you get paid not for the whole 2 months, but for 50%. So it's about 4 weeks of paid parental leave until the child is of 4 years of age. The other 25%, so equivalent to 2 weeks, are paid when the child is between 4 years and 6 years, and the remaining 25%, so the other 2 weeks, are paid between 6 years and 8 years. So if you decide to take all the 2 months when the child is until 4 years, you will not get paid for whole 2 months, but only for the 50%.
Now we're moving on to the last two legislations for today. So we have banking of hours. So what do we refer to when we say banking of hours? So this is a system that is mainly used in sectors where the workload fluctuates between seasons, such as tourism and retail. It allows extra hours over and above the normal weekly hours to be worked during periods of higher work activity, therefore when the company is more busy, which would be redeemed then during periods of lower activity by having working hours below the normal working hours. Thus, the monthly salary will remain constant throughout the year. So, for instance, if a hotel would be busier more in the summer months and less busy in the winter months, the employee would work more in summer and less in winter. However, they would be getting the same salary throughout. This cannot be done without this system. And this system can be employed only through an authorization by the DIER. So, an employer can basically request authorization from the DIER, and if they get approval, then they can implement this system. The employee must be given prior notice of the number of hours and roster to be worked in the following 4 weeks under the banking of hours scheme. And when does this banking of hours scheme apply? So, before the banked hours could be redeemed, such outstanding banked hours are to be paid at the applicable overtime rate. So, for instance, if an employee is terminated during winter, but they have worked a lot in summer over and above, for example, the 40 hours, they would have to get paid the remaining hours as overtime. And when it comes, for example, to the lesser hours, if the employee would leave in winter, however has worked a lot in summer, the employer does not have the right to deduct any money because they got the same salary in summer. So this is very important to note. If an employee may be required to work in excess of the scheduled hours of work on a particular day, such extra hours are to be paid at overtime rates accordingly. And then we have fines permit. So what is a fines permit? Fines permit is also obtained from the DIER, and this basically allows employers to deduct a certain amount of money. As we have said previously before, the employer has no right to deduct any money from your salary except obviously for tax and NI. However, if they obtain a fines permit from the DIER, they would be able to deduct a certain amount of money. And these fines permits are given only under certain circumstances. So for instance, if the employees are not wearing their uniform, if they are not wearing their protective gear, if they are not punching correctly at work, the employer can enforce these deductions. Again, they would need to get permits from the DIER. So, and these permits are issued on the following conditions. The concerned employees are issued with a statement clearly showing the specifications of the fines. So it is important that the employees would obviously be informed beforehand. If these employees are not informed beforehand, but the employer still obtains the DIER permit, this would not be valid. It would be invalid because they would have to be informed. The employer shall keep a register showing every fine imposed in instances where DIER inspectors come and inspect these registers, and fines are to be kept to a minimum and resorted as a means of disciplinary action only when other means of persuasion prove to be of no avail. The amount deducted in the form of fine shall not exceed in any 4 consecutive weeks 10% of the wage on the 4 weeks in respect of each employee. And this authorization is granted for a year, and it can be renewed once it has expired. Now, thank you for listening. If you have any questions, now is the time to ask. We just want to tell you that you can contact us, as I said, on 1575 or 1576 in case of employers. During the winter hours, we open from 8 until 3:30, and during the summer, we open from 8 until 12.